In Florida, we recently finished getting an 1115 waiver with CMS. I'm sure you're aware. It was a long, hard process that included a state lawsuit against the federal government over the process. Florida has had an uncompensated care fund, which we call the LIP, the Low Income Pool, for our Medicaid program for almost a decade now, which should have been a simple process, in my opinion, to renew that fund, turned into a long, drawn-out affair by CMS, who decided to change the rules this year. Ms. Saratani, when HHS reviews and issues 1115 waivers, do they follow precedent established with other approvals, or is every application reviewed from the beginning?
If I understand the question, is it when HHS approves a demonstration, does that set precedent for others?
Yeah, for others, and maybe previous applications for that particular state as well. Or is that, do we have to start from the beginning? First with others. Yes.
We haven't looked at differences in, how HHS approves new approvals versus extensions versus amendments, which are all different ways that HHS can approve things. That said, I think HHS, with every new approval, does set precedents for other states to follow. And there are many demonstrations that have been operating for many years, right, as someone mentioned.
Okay. Next question. HHS provided GAO with 4 general criteria. You stated that. That state programs must meet to receive the funding through the 1115 Medicaid waiver. However, the criteria are so broad that they can be interpreted in many different ways. Question, is such subjectivity fair to states and stakeholders, and does GAO think that the HHS needs to issue regulatory guidance explaining these criteria?
We believe that more specific criteria, written criteria, are needed, and otherwise we believe that many questions about the basis for the decisions, as well as the consistency of approvals, will continue to rise.
And I understand that the GAO was not even aware of these criteria. Is that correct?
Yes, correct.
Okay. Next question. GAO's work suggests that there is likely significant duplicative federal funding streams for state programs under waivers and other HHS programs. Do we know if HHS reviews for duplicative payments prior to or after approval? If not, what is the mechanism for HHS to prevent duplication, or at a minimum recoup duplicated funding, save billions of dollars for us?
We have not looked at how HHS monitors spending post-approval. We have looked at, what protections they provided in the terms of the demonstrations regarding preventing duplication, and found variation, and in some cases no assurances that the new spending for Medicaid would not duplicate other purposes.
Okay, next question. In my estimation, there is a clear lack of uniformity in CMS decision making. I think it's pretty obvious from the testimony. Are there criteria that could explain why 2 states of a similar nature get uncompensated care pools approved for different lengths of time? And I know my friend Mr. Guthrie touched on this as well.
There are no criteria that would explain that, and that's part of why we're recommending that there be criteria. We feel like that's important for transparency and for a common understanding of why the Secretary is making certain approvals.
Thank you. One last question, if you don't mind. I've got a few more seconds. Have you ever encountered an instance when CMS would force a state to take an action that their governor and the legislature did not want to take in order to renew the 1115 waiver that was already in existence?
I'm not aware of that kind of circumstance, but we typically have looked really at the approvals. the federal level.
All right, very good. I yield back. Thank you, Mr. Chairman.